Today we'll be looking at the Supreme Court case of Tinker versus Des Moines. The case was the Tinker family against the Des Moines Independent Community School District in Des Moines, Iowa. In December 1965, a group of students in Des Moines held a meeting in the home of 16-year-old Christopher Eckhart to plan a public showing of their support for truce in the Vietnam War. These students decided to wear black armbands throughout the holiday season and to fast on December 16th and New Year's Eve. The principals of the Des Moines schools learned of the plan and met on December 14th to create a policy that stated that any student wearing an armband would be asked to remove it, with refusal to do so resulting in suspension. On December 16th, Mary Beth Tinker and Christopher Eckhart wore their armbands to school and were sent home. The following day, John Tinker did the same thing with the same result. The students didn't return to school until after New Year's Day, the planned end of their protest. Through their parents, the students sued the school district for violating the students' right of expression and sought an injunction to prevent the school district from disciplining the students. A U.S. district court sided with the school, ruling that wearing armbands could disrupt learning. The students appealed the ruling to a U.S. Court of Appeals for the Eighth Circuit and affirmed the decision without opinion. They lost and they took their court case to the United States Supreme Court. The question that applies to this court case is, does freedom of speech apply to public school students? The answer is yes. In 1969, the United States Supreme Court ruled in a 7-2 decision in favor of the students. There are 3 reasons of why the court decided that this was legal. The court first held that in wearing armbands, the petitioners were quiet and passive. They were not disruptive and they did not infringe upon the rights of others. In these circumstances, their conduct was within the protection of the Free Speech Clause of the First Amendment and the Due Process Clause of the 14th Amendment. Second, the First Amendment rights are available to teachers and students, subject to application in light of the special characteristics of the school environment. And lastly, a prohibition against expression of opinion without any evidence that the rule is necessary to avoid substantial interference with social discipline or the rights of others is not permissible under the First and 14th Amendments. The High Court agreed that the students' free rights should be protected and said students don't shed their constitutional rights at the schoolhouse gates. In order to justify the suppression of speech, the school officials must be able to prove that the conduct in question would materially and substantially interfere with the operation of the school. The biggest reason why the Des Moines School District was voted against was because there was no actual interference of learning. It was just a fear of possible disruption. After Tinker versus Des Moines, there were 2 important court cases that took its precedence: Bethel School District versus Fraser and Hazelwood School District versus Kohlmeyer. The question regarding Bethel School District versus Fraser was, does the First Amendment prevent a school district from disciplining a high school student for giving a lewd speech at a high school assembly? The ruling was no. The court found that it was appropriate for the school to prohibit the use of vulgar and offensive language. In a high school-sponsored newspaper, the principal received 2 articles that were deemed inappropriate and ordered to have the pages withheld from publication. Did the principal's deletion of the articles violate the student's right under the First Amendment? The court ruled no, because the schools must be held to set high standards for student speech. These 3 court cases have a huge classroom impact because today students are able to voice their opinions in the classroom by silently protesting without having to worry about their discipline. They have a chance to make their voices heard just like people are outside of the classrooms. This opens a lot of doors for things later on down the road, like other court cases.